few times a week, my inbox lights up with a particular kind of message from someone who isn't my client. I don't know them, they don't know me. But what they do know is distress, particularly the distress of a request for evidence in an EB-1A case. These panic emails usually ask me some version of the question, what now? I'm Stefanakorli, an immigration attorney, and I'm here to do for you what so many people have done for me over the years, and that is to provide important information that could maybe transform a life or two. What I'm about to explain could determine whether your EB-1A road for permanent residency survives the RFE, or becomes another victim of poor timing and inadequate foresight. The timing problem in EB-1A cases follows a logic that a lot of petitioners don't fully understand until maybe it's too late. You see, EB-1A success operates on what I call the foresight principle. The crucial decisions that determine your case outcome should be made before you file, not after you receive an RFE. By the time that government envelope arrives, you've entered a different phase of the process, one where your options have been constrained. Phase 1 would be the preparation phase, when everything is still possible. During initial petition preparation, you can freely define your field of extraordinary ability and do so strategically. You can freely gather the strongest evidence. You can craft reference letters purposefully, build a compelling narrative, a compelling and comprehensive narrative around your achievements, a persuasive, compelling, comprehensive narrative around your achievements. Here you're working from a blank slate. Phase 2, filing phase, where possibilities become fixed. The moment you submit your petition, your evidence base, the evidence that you've already submitted, is in, it's locked in. By that I mean it can't be unsubmitted. And your field of extraordinary ability is largely set. Your reference letters are submitted, they can't be unsubmitted, and your arguments are also in. Phase 3 is the RFE response phase, when options have dwindled. Now you discover whether your phase 1 decisions were sufficient. If they weren't, you face RFE constraints. More on those later. I promise I will tell you more about those later. But they do include a deadline to respond to the RFE, a proscription on material changes to your case, no new post-filing date facts, also no ability to take back something harmful that you may have submitted. Same thing about reference letters. You can't unsubmit reference letters. What they say has already been said. There's no unringing of certain bells. When the RFE arrives, your first challenge isn't wholly legal. It is in large part psychological. You see, you have to accurately assess what type of fight, what type of challenge you're facing. The problem, you probably cannot objectively evaluate your own case. You're too close, you're too invested, you're possibly too desirous to see things clearly. Not to mention, you probably just don't know this particular area of the law well enough. Still, RFEs, they exist on a spectrum. At one end are bureaucratic errors, cases where USCIS got the law wrong or maybe misunderstood or just missed some facts, some evidence. At the other end are legitimate RFEs where USCIS correctly identified some weakness in your case, sometimes a fundamental weakness in your case. Two pathways emerge. Pathway A, we'll call it the Baseless RFE pathway. Sometimes, often, USCIS just gets it wrong, and errors are more common than you might expect. Consider this real example. Petitioner provided evidence that he judged a national student design competition. USCIS issued an RFE stating, among other things, the judgment was of students, not other professionals in the field. Therefore, this criterion is not met. This represents a clear legal error. The rule requires judging the work of others. It contains no requirement that the work be of other professionals. The rule does not prevent the judging of a student competition from satisfying this criterion. The officer here invented a requirement that doesn't exist. This is just one of countless examples of errors that USCIS officers make under time pressure, to be fair. Sometimes the errors are legal errors like the one I just gave you. Sometimes they're more fairly characterized as factual errors. USCIS will mischaracterize or just miss a piece of evidence. For baseless RFEs, a strong legal brief can provide effective correction. The response might cite relevant law, cite relevant already submitted evidence, apply the law to the evidence systematically and persuasively, reference prior AAO decisions, and demonstrate why the adjudicator's reasoning is flawed. What exactly is called for will depend on the particulars of the case and also depend on principles of persuasion. But an immigration attorney responding to these types of requests for evidence will typically be successful. Pathway B, the legitimate RFE. The real dangerous situation occurs when USCIS correctly identifies a real weakness in your case. These cases present the deeper challenge because the constraints on RFE responses sometimes severely limit your ability to address the initial errors. When USCIS issues a legitimate RFE, the RFE often stems from a common error. I'll give you 3 of these common errors, and each carries its own set of response constraints. Error 1. Poor matching of the facts to the law. Here you understand the law well enough, you just misjudge the potency of facts. I'll give you an example. Criterion 1 requires you to show that you are the recipient of a lesser nationally or internationally recognized prize or award for excellence. And you understand that. You also understand that to establish excellence, relevant considerations include, but are not limited to, the criteria used to grant the award or prize, the national or international significance of the award or prize in the field, the number of awardees or prize recipients, and the limitations on competitors. Here's an example of this error, and I'll keep it very simple. You think that an award that had 25 awardees and 50 competitors is an award for excellence. USCIS disagrees. Here, you don't have an issue with understanding what the law is. You just have an issue of whether 25 out of 50 falls into one category or another category, whether it falls into the excellence category or the other category. This is not an issue that relates to whether you understand the law correctly or not. You do. It's an issue that relates to whether the facts are potent enough to establish a particular legal conclusion. If they're not potent enough, the next question becomes, do you actually have facts that are potent enough to establish the legal conclusion? Do you have facts that are potent enough to establish that you meet this criterion? That becomes a very important question if you need this criterion to get to 3 of 10, as required by the law. Error number 2 comes when you misunderstand legal requirements. You argue that you satisfy a particular criterion when you're operating under a fundamental misapprehension of what the law requires. Here, an important question is, can you establish the criterion when you do properly understand what the criterion requires? Error number 3 deals with you failing to argue that you are near the top of your field and that you have sustained national or international acclaim. This is easily the most significant and also the most common error that I see. Often petitioners never make a serious effort, never even come close to demonstrating that they are near the top of their field or that they have sustained national or international acclaim. And the law requires that they show both. Consider a research scientist who meets 3 of the 10 criteria. She's authored many scholarly articles. She served as a peer reviewer and has received a professional award. Her petition includes solid evidence for these 3 criteria, but provides virtually no argument for why she is among the small percentage at the top of her field, or why she has sustained national acclaim. Her petition package, which is quite typical, treats the second part of the EB-1A analysis as an afterthought, or treats its satisfaction as a foregone conclusion if only she satisfies 3 of 10 EB-1A criteria. That is a misunderstanding of the analytical framework. Sadly, it's a very common misunderstanding. So many people, when they get an RFE, they face the prospect of having to build arguments related to this second part of the EB-1A analysis from scratch. But now they have a time deadline. And by this time, reference letters have already been submitted, except when they were written, they didn't have the second part of the EB-1A analysis in mind. But a petitioner does have to demonstrate that they have risen to the very top of their field and that they have sustained national or international acclaim. That is a requirement. And compared to the first step of the EB-1A analysis, the 3 out of the 10 criteria step, the second step is much trickier and it's much less straightforward. You may find these errors sometimes are hard to address during an RFE response due to a few inflexible constraints and a couple of practical challenges. Here's one constraint that I've mentioned: the deadline. You will likely have about 3 months to respond. This likely will be enough time if you get started immediately. But depending on the day you do get started in earnest, the date you hire a lawyer, the date you secure additional reference letters if you do that, the date you secure additional evidence if you do that, the date you get documents translated, the amount of time it takes your attorney to draft the cover letter, the legal brief, depending on all that and more, you could be running up against the deadline. Surely you wouldn't be foolish enough to not submit anything. But you may not, because of the time limit, because of the deadline, submit something that's optimized, that's optimal, which would be a shame, which could have a big impact on the outcome of your case. Another constraint is prohibition on material changes. You cannot significantly alter the fundamental nature of your case. What constitutes a material change will be arguable, but there is a prohibition on material changes to your case. Another constraint is that you can't ignore already submitted evidence. Every document, every reference letter, the cover letter that you submitted remains part of your case. You can't withdraw harmful evidence or problematic reference letters. And USCIS has the habit of cherry picking damaging language from your own submissions. Here's an example, a reference letter. It describes you as someone who shows incredible promise, who will undoubtedly become one of the leaders in the field. To you, this sounds like high praise. To USCIS, the phrase will become, and even the word promise, to USCIS, that is definitive evidence that you have not yet risen to the top of your field. You're getting there, but you're not there now. Here's another constraint. No post-filing date facts. USCIS has the habit of saying eligibility must be established as of the date of filing. USCIS generally enforces the rule that it's not going to consider new facts if those facts arose after you filed the petition. So if you won an award after filing, or a statue was built in your honor, or papers were accepted for filing, or you had a new art exhibition, all of that is useless for your case, regardless of how case strengthening it might be. I want to tell you a couple of practical challenges when it comes to responding to requests for evidence. USCIS does not need to be right about everything. They only need to identify one meaningful weakness that you do not address in your response to the request for evidence to deny your case. Failure to address even a single issue can result in the denial of your case. You must successfully address every concern raised. The asymmetry of this situation favors USCIS. What's really truly a shame is that USCIS often provides little guidance on everything that you may have done wrong. It depends on the RFE, but often they focus extensively on the 10 EB-1A criteria, often getting some of the law or facts wrong in the process of discussing how you handle them. And they spend virtually no time on the second part of the EB-1A analysis, the more difficult part of the EB-1A analysis, whether you demonstrate a national or international acclaim, and whether you are among the small percentage at the top of your field. This information gap puts you in a disadvantaged position. Another practical challenge involves finding quality legal help. In an instance where you get a legitimate RFE, your case likely requires an attorney. But your case at this point is the legal equivalent of a fixer-upper in a bad neighborhood. It's less attractive, it's more expensive, and it requires someone who really knows what they're doing. Finding a good lawyer at this late stage, it can be like trying to find a plumber on Christmas Eve. So let's confront the central question, honestly. Can your case be saved? Of course, that answer will depend on which type of RFE you received, whether you received a baseless one or a legitimate one. If it's baseless, for example, full of factual or legal errors, a good, experienced attorney can craft an aggressive, persuasive legal brief that should result in a winning case for you. That attorney's response should be comprehensive. It should cite the law, apply the law to the facts systematically, persuasively, maybe reference AAO decisions, and demonstrate precisely why the adjudicator's legal analysis is wrong. The response, a brief, should also, by the way, well position your case for an appeal should the adjudicator fail to recognize their error. These cases offer the best chance for successful RFE response. Now, if you have a legitimate RFE, whether your case can be saved depends on how extensive and deep your errors were, and whether you actually have the goods. Essentially, if your case, if it were prepared by competent counsel from the beginning, would it have likely resulted in an approval? That said, many cases can successfully be saved through timely, effective legal intervention. If you're already holding a RFE letter, or you see that USCIS has sent one when you look up your case online, understand this. Now is not the time to panic. It's too early to say you're without options. It's too early to say that your case is not winnable. The game has changed, sure. The stakes are higher, the margin of error has shrunk, but skilled intervention maybe can make the difference between success and failure for you. I wish you the best. Now, go subscribe because there will be more content like this on the way.